because now I have no more power. It's interesting because they'll come up with stuff that you didn't even talk about as part of their decision. We shake our heads, and obviously post motions may fly as a result of that. I've had juries give me more than what I've asked for, and I worry going home, is that going to be upheld? And it was. But there's just things they do and things they see and hear, and their commonplaces do. They're absolutely amazing to me. But that's why the Supreme Court said what they said. They said it is a strict but-for test that ignores settlement opportunities lost due to the attorney's negligence. In such a case, the more negligent the attorney, the more difficult of a task it is proving causation. And so let's say he doesn't do discovery, so he doesn't know that things are out there for purposes of settlement. Right? So now you see that the cloudy, what's the settlement value then if you don't know? Proximate cause is difficult. The court in that case ruled that we cannot endorse a blanket proposition that requires a plaintiff to prove in every instance that he or she would have been successful in the underlying matter. The Supreme Court said, well, you don't have to prove that you can reverse, because the attorney is there, the conviction. You don't have to change the civil award that was given. You can talk about the plea bargain arrangements, you can talk about the settlement opportunities, and those are issues of fact for a jury to decide. So we have been heavily leaning on that case as a result, therefore, and it means that, simply put, you can go to a jury, and that's a good thing. Because whenever you can go to a jury, the fear in everybody's eyes is there. Doctors have a little bit more successful time than lawyers. Tort reform has been such in the papers that it has made the white coat, when they sit up there, pretty impenetrable. I think the statistics show about 80% of medical malpractice cases die on the vine, either by dismissal or by verdict. A lot of those, when you do the research, you'll see are cases that people unfortunately get filed on the heels of a case. They come in with the statute of limitations tomorrow. Well, you got to file. So those kind of statistics are skew the overall aspects of it. But legal malpractice cases are different. Juries do not like lawyers. They do not trust lawyers. So your job as the lawyer that's sitting on the stand or as sitting in the defense or plaintiff's case is to be credible. You're not going to be liked. You have to know more than what, you obviously know more than what they know, but you have to know more than what the defense or the plaintiff knows and articulate that. I often tell people it's a theater production. I'm draping in witnesses just like you would see acts in a play, and I'm providing documents to be able to have them prove through their testimony what is necessary. I tell them during opening argument, I hopefully tell them to the witnesses, and I tell them again at the end during closing argument, because I often use a lot of demonstrative evidence as well, because I firmly believe juries retain more of what they see than what they hear. And particularly in legal cases, there's a lot of stuff that I've heard so many times, oh, that's mumbo jumbo. I don't understand that. Well, you as a lawyer in a personal injury case, I don't care what kind of case that, your job is to make sure they understand it. And by beating it in their brains and hope maybe 2 out of the 8 understand it. Because maybe they'll, in the back, be the foreman. So here, let's move on then to the second things that, in Roman numeral number 2. You have to have the expert, like I talked about, prove that somebody did something wrong. And it's this Hunt case, I happen to know Dick Hunt, having practiced up in Dayton for a number of years. This case here absolutely flabbergasted me. Dick had somebody come into his office that had a misread slide, and eventual the man died, so there was some issues over the hospital liability. But he came in to see Dick 14 months after the incident of the misread slide. Now, most of you know that there's a statute of limitations of 1 year, unless it can be extended by a tolling agreement, or somebody was out of state where it tolls the statute, and or the cognizable event, which is now what this case points out. So Dick goes ahead and says, look, I don't practice in this telephone call. I don't practice in this area of law, but I know a guy that does. Calls up the guy, and the guy up in Columbus says, you know what? It's past the statute of limitations. It's 14 months, 2 months past it. You know, it's not going to be a viable claim. So like a year later, the plaintiff's still having problems, hasn't passed yet, comes back and says, you know, I still think there's something wrong here, because look at the continuing treatment that I'm getting. It's just not right. Calls up the attorney in Columbus again, says, what do you think? He goes, no, it really is a flow from the earlier damages that are just getting exacerbated now. I don't see it. Statute of limitations problem. So that was 82 and 83. And 89, guy dies in 84. 89, 7 years later, spouse is watching a television ad. She sees Dyer Garfield, I don't know who it was. Advertising negligence, she goes to see him, and they say, now, when did you learn about the fact that somebody did something wrong? Oh, well, it wasn't until blah, 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 when they told us the misread x-ray. It wasn't when the event occurred. They sued the lawyer. Dick went up and down in that Court of Appeals 2 or 3 times, but he got up to the Supreme Court here where they said, now, we're going to go ahead and rule that the statute of limitations doesn't begin until the client knows of it or 1 year, whichever is the later. And as a result, he was remanded, went back down, they fought around and went back up to the courts. Dick eventually got out of it. But the fact of the matter is that that cognizable event, just like in a medical malpractice case, parallels each other. Now, might have been last year, I'm pretty sure it was last year, a statute that the insurance companies are fortunate enough to lobby went into effect, a statute of repose. It went into effect for medical claims or no claim older than 4 years, period. Unless you learn about it in the 4th year, then you got 1 more year. So now you're limited in cognizable event cases of medical malpractices to 4 plus 1 if you learn it in the 4th year. But that's not the case in legal malpractice cases. So you can go on and on and on and get to a point where somebody learns about it, and that's very problematic. Witnesses leave, witnesses die, records get destroyed. So if you do have a case like that, and I have seen them, I'm very rarely going to accept those for a lot of different reasons. Just common sense makes sense that if you felt something was wrong as a plaintiff, that you would have sought out a lawyer. And if you sought out a lawyer, that's a cognizable event. So the Landis case, when you look it over, you shake your head and think, wow, eventually Dick got out of it, but boy, he went through a lot to get there. One of the quotes that the case had is, the essential element as to whether or not an attorney-client relationship has been formed is the determination that the relationship invoked such a trust and confidence in the attorney that the communication became privileged and the information exchange was confidential to invoke attorney-client privilege. What did I talk about before? Dick said you don't have a case, they relied upon it. Okay? So when you give advice, you are now establishing that confidential relationship. You can't go out in the street. Would everybody agree with me? Dick couldn't go out in the street and say, hey, I learned that Tom Landis doesn't have a case against such and such doctor. No, you learned that during the scope of your attorney-client relationship. And as such, that relationship bears the first element, and then the duty goes out from there, which is where, actually, at the end of it, that it ended up. So in Dick's case, it ended up being issues of fact that had to be decided. Every once in a blue moon, I don't think I've ever done it, but I've seen cases where I think I can do it, I'm just too chicken to do it. You don't need expert testimony. The old res judicata. So it speaks for itself. No, res is loquitur, I'm sorry. It speaks for itself. Boy, I tell you what, it better be a left arm being cut off versus the right arm being cut off before I would take that case. I think you still need an attorney to testify as to the proximate relation of damages, irrespective if you're in a legal malpractice case. I do think differently if it's a medical malpractice case. But case law does say that you can go ahead and do that. And remember, too, different experts for different things. If I've had this. I don't like it. Matter of fact, I had it in a recent case where the expert says, I'm an expert in bankruptcy law. I'm not an expert in damages that flow from it economically. I'll testify it was wrong and it caused damages. I don't know what damages. Well, I better go get somebody else to opine that those damages that flowed from that are directly related to the error that the first attorney testified to. That clouds it up a little bit. It gives the lawyer some leeway to pry and pick upon what is it that you relied upon, what is it that you reviewed. So expert testimony, you have to have it or you fail on the ability to prosecute a legal malpractice case. The first thing, too, that when I am doing legal malpractice cases is really honing down on that statute of limitations. Just like the Court of Appeals is looking for 54B language, they're not even going to try to listen to your case if they can throw it out on it not being a final appealable order. I look at statute of limitations cases because that's the first thing a defense firm will do. They don't care about the merits. If it's a statute of limitations case, they're digging in their heels. So be very clear when you come in to illuminate that. I have numerous times called up attorneys and said, I don't want to sue you because the statute's next week. Will you enter into a tolling agreement to allow me the opportunity to investigate this so that I don't put your name in the newspaper? And I don't think I've been turned down. And I've had lots of different attorneys appreciate that. And that goes a long way to when you're then later on trying to settle. They remember that. Because oftentimes, when you get the records, when you get the expert opinion, just like in med mal cases, it may look like it, but it wasn't. And so until you get your ducks in line, it's a good habit to not file suit first and ask questions later. So let's go to some examples of the malpractice. I already pointed out the overcharging a client case, and you see the Wilkerson site there. There's no doubt in my mind